everyone, welcome to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. Components of maritime law. Maritime liens. Although admiralty actions are frequently brought in personam against individual or corporate defendants only, the most distinctive features of admiralty practice is the proceeding in rem against maritime property, that is, a vessel, a cargo, or a freight, which in shipping means the compensation to which a carrier is entitled for the carriage of cargo. Under American maritime law, the ship is personified to the extent that it may sometimes be held responsible under circumstances in which the ship owner himself is under no liability. The classic example of personification is the compulsory pilotage case. Some state statutes impose a penalty on a ship owner whose vessel fails to take a pilot when entering or leaving the waters of the state. Since the pilotage is thus compulsory, the pilot's negligence is not imputed to the ship owner. Nevertheless, the vessel itself is charged with the pilot's fault and is immediately impressed with an in-court maritime lien that is enforceable in court. Maritime liens can arise not only when the personified ship is charged with a maritime tort, such as a negligence collision or personal injury, but also for salvage service, for general average contributions, and for breach of certain maritime contracts. In a proceeding in rem, the vessel, cargo, or freight can be arrested and kept in the custody of the court unless the owner obtains its release by posting a bond or such other security as may be required under the applicable law or as may be acceptable to the plaintiff. More frequently, however, the owner will post security to avoid a threatened arrest, and the property never has to be taken into custody. When the judgment is for the plaintiff in a proceeding in rem, there will be a recovery on the bond or other security if the owner of the property does not pay, or if security has not been posted, the court will order the property sold or the freight released in order to satisfy the judgment. The sale of a ship by an admiralty court following a judgment in rem divests the ship of all pre-existing liens. The sale of ship by an admiralty court following a judgment in rem divests the ship of all pre-existing liens, and not merely those liens sought to be enforced in the proceeding in rem. By way of contrast, the holder of an in personam judgment against a ship owner can, like any judgment creditor, have the ship sold in execution of the judgment, but such a sale, unlike the sale under an admiralty judgment in rem, does not divest existing liens. The purchaser at the execution sale takes the ship subject to all such liens. Thus, an in rem proceeding has decided advantage over a proceeding in personam in a case in which the ship owner is insolvent. Efforts have been made from time to time to increase the security value of ship mortgage in order to encourage lending institutions to finance vessel construction, but these efforts have not been very successful, largely because of differences in national laws respecting the relative priorities of mortgage and maritime liens. Under general maritime law, there is a complex hierarchy of maritime liens, that is to say, in a proceeding that involves distribution of an inadequate fund to a number of lien claimants, liens of higher rank will be paid in full in priority over liens of a lower rank, and in most countries a ship mortgage ranks lower than a number of maritime liens. Attempts were made to harmonize some of these conflicts by international conventions signed in 1926 and 1976, but the first failed to win widespread support, and as of the end of 1983, the second had been ratified by only half of the signatories required for the convention to enter into force. Shipping charters. The function of ships other than warships, pleasure craft, and surface vessels of various types is of course transportation of cargoes and passengers. In the Jet Age, the passenger carrying segment of the shipping industry has lost much of its former importance, but the quantity of goods transported by water continues to grow as the world economy expands. The great majority of the contracts governing the carriage of goods by water are evidenced either by charter parties or by bills of lading. The term charter party, or a corruption of the Latin carta partita or divided charter, is employed to describe three widely differing types of contracts relating to the use of vessels owned or controlled by others. Under a demise or bareboat character, a ship owner delivers possession The ship owner delivers possession of the vessel to the charterer, who engages the master and crew, arranges for repairs and supplies, and in general function in much the same way as an owner during the term of the charter. A much more common arrangement is the time charter, whereunder the ship owner employs the master and crew, and the charterer simply acquires the right, within specified limits, to direct the movements of the vessel and determine what cargoes are to be carried during the charter period. Under both demise and time charters, the charterer pays charter hire to the use of the vessel at a specified daily or monthly rate. The third type is the voyage charter, which is essentially a contract of affreightment or carriage. Most voyage charters provide for the carriage of full cargoes on one voyage or a series of voyages, but occasionally a charterer contracts for the use of only a portion of the carrying capacity of the vessel, in which case the governing contract is described as a space charter. Under a voyage charter, it is customary for the master of his agent to issue a bill of lading to the shipper, who is usually the charterer, although as between ship owner and charterer, the voyage charter remains the governing contract of carriage. The bill of lading serves only as a receipt and as a document of title of the goods. Ocean bills of lading are usually in order form, that is, they call for delivery for the order of the shipper or of some other designated party. Such as of lading may be negotiated in much the same way as a check, draft, or other negotiable instrument, which means that a bona fide purchaser of the bill of lading takes it free and clear of any defect not appearing on its face. Thus, if cargo is externally damaged on shipment, but the damage is not noted on the bill of lading, the carrier will be barred from establishing that the cargo was in fact damaged before it came into the carrier's custody. Once a bill of lading issued under a voyage charter is negotiated to a bona purchaser, it becomes the governing contract between the carrier and the holder of the bill. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.